Hello friends, very warm welcome to my business laws channel. Till now friends, I have covered chapter 7. Today I am going to take up chapter number 8, which is discharge of contract. Two questions are very important from this chapter. The first one is regarding modes of discharge of contract. And the second is doctrine of subsequent impossibility of contract, cases covered and exceptions. So first of all, friends, I would like to define what is the meaning of discharge of contract. You all know that as per section 10, a valid contract gives rise to rights and obligations between the parties. A contract is said to be discharged when rights and obligations arising out of the contract are extinguished or they come to an end. When rights and obligations under the contract, they come to an end, then the contract is said to be discharged or the contract is said to be terminated. So now the question arises, which are the various modes of discharge of contract? Various modes of discharge of contract, they are, friends, first one is performance. Second is by agreement. Third is impossibility of performance. Fourth is lapse of time. Fifth one is by breach of contract. And the last is by operation of law. And now, friends, in this video lecture class, I'll take up all these 6 points one by one. First is, how is the contract discharged by performance? What is the meaning of the term performance? Contract is said to be performed when both the parties to the contract, they perform their respective obligations under the contract. Take the example of seller and the buyer. Say seller has delivered the goods to the buyer as per the agreement and buyer has paid the price to the seller. Then the contract will be known as performed and discharged. So friends, this is the meaning of the term performance. Performance can be of two types. One is actual performance and second is attempted performance. Attempted performance is also known as tender. Now, actual performance, a contract is said to be actually performed and both the parties fulfill their respective obligations arising out of the contract according to the terms of the contract. So just now I've given you a good example of seller and the buyer. The contract which takes place between the seller and the buyer, both the parties, they perform their respective obligations under the contract. This will be the example of actual performance of contract. Now, on the other hand, another type of performance is attempted performance, which is also known as tender. Now, this is where performance is offered. As it is clear from the name, attempts are made, but these attempts are not accepted by the other person. Take the example of seller of goods. Seller of goods has offered the delivery of goods to the buyer, but buyer has not accepted. Then, friends, the result of this will be that seller will be discharged from his liability. He will not be liable again because he has done his duty, he has performed his part of obligation, and now he will not be responsible to further deliver the goods to the buyer. So this is the meaning of attempted performance. Attempted performance is also known as tender. And now, friends, I'll take up the second point, which is discharge by agreement. Now, discharge by agreement. How is the contract discharged by agreement? As you know, friends, the contract is a sum total of offer plus acceptance. Now, and then offer plus acceptance is equal to agreement. Agreement plus enforceability is equal to contract. As the contract is based upon agreement, similarly, friends, contract can also be discharged through an agreement. Now, it can be discharged by express agreement or implied agreement. Now, implied agreement, discharge of contract by implied consent may take the following shapes. And now, friends, 4 to 5 points I'll discuss under this when the contract gets discharged by implied consent. First is novation. What is novation? The term novation implies substitution of new contract in place of old one. It may involve a new contract between the same parties, or there could be change of parties. See, for example, friends, A owes money to B under a contract. It is agreed between A, B, and C. Earlier, there were two parties. Now, the agreement takes place between A, B, and C that B shall henceforth accept C as his debtor. He will not accept A as his debtor, but he will accept C as his debtor. So the old contract of A and B comes to an end, and the new contract between B and C comes into existence. But there are certain essentials of valid novation. First one is mutual consent of both the parties. Mutual consent is must. If the creditor in this example, B is not willing to accept the money from C, then in that case, the new contract will not be valid. The old contract will exist and the new contract will not come into existence. And the second essential is the new contract must be capable of being enforced at law. New contract must be capable of being enforced. If it is not capable of being enforced, then the new contract will not come into existence. The old contract will exist. Novation must take place before the expiry of the time of performance of original contract. It's very clear, friends. So these are the three essentials of novation. Then only novation will be valid. Now, next point is alteration. Now, it occurs when one or more of the terms of the contract are altered by the mutual consent of the parties to the contract. When we talk about alteration, it may be bilateral or unilateral. Bilateral is with the consent of both the parties, or mutual, we may say unilateral is when it is made by one of the parties to the contract. The difference between novation and alteration. So, friends, these two terms are different from each other. One is a novation, other is alteration. Alteration implies change in the terms of the contract, whereas novation may imply change in the terms of the contract or change in the parties to the contract. So, friends, you all know the term novation is wider as compared to the term alteration. Novation includes alteration, but vice versa is not possible. The third point is rescission. Rescission or cancellation. When the parties cancel all or some of the terms of the contract by mutual consent, it is called rescission of the contract. Rescission or cancellation of the contract. So similarly, in case of breach of a contract, the aggrieved party can rescind the contract and file a suit against the guilty party for compensation. So the right of rescission is also available to the aggrieved party whose consent was not free in case of voidable contract. So this rescission may be total or partial. Totally the contract may be cancelled, or the contract may be cancellation may be partial. The entire contract has not been cancelled, but part of the contract has been cancelled. So friends, breach term has been used in this point. Breach is non-fulfillment of a promise on the part of one person. Any person may commit breach of contract. When we talk about contract between X and Y or seller and the buyer, so either party can commit breach of contract. Any party who does not fulfill his part of obligation, we say breach has occurred. So breach chapter is chapter number 10. In detail, I'll teach you there. And rescission is also one of the remedies which is available to the aggrieved party in case of breach of a contract. And then in case of voidable contract, which you all have studied, in case of voidable contract, friends, you must be very clear about this term. Voidable contract where consent is not free. It always provides two options to the aggrieved party. One is affirmation, second is cancellation. If the party opts to cancel the contract, then also the contract will come to an end. And now next point is remission. Remission is acceptance of a lesser performance than what was due under the contract. Now, there are two terms here. One is accord, second is satisfaction. And these two terms have been used under the English law. When the promisee accepts a lesser amount than what is due under the existing contract, this is known as accord. And when actual payment is made by the promiser, then this is known as satisfaction. Friends, the party will be discharged from his liability only, when accord is followed by satisfaction. Say debtor A owes B rupees 5,000. A pays to B rupees 2,000 and B accepts in satisfaction of the whole debt. Here an agreement to pay 2,000 is accord, and actual payment when it is made by A to B, this will be known as satisfaction. So the whole debt is discharged because 2,000 rupees has been accepted by the creditor in full and final settlement. According to section 63, the promisee is allowed to dispense with or remit wholly or in part the performance of the promise, to extend the time for performance. He may also, instead of accepting the lesser amount in full and final settlement, he may also extend the period. See, the debt was taken for 1 year period, but debtor after the expiry of 1 year is not able to make the payment. Then creditor, he may say that he may request the creditor to allow him 15 days period, and creditor allows. So here also we'll say that here contract will be valid. Now next is to accept any other consideration than agreed to in the original contract. Any other consideration which has been accepted by the creditor from the debtor, that will also be valid. That will also discharge the party from its liability. Now friends, the last point is waiver. Last and the fifth point is waiver. It means abandonment of the rights by the parties to the contract. No consideration is required for the waiver. Waiver means, the term waiver means to give up, to abandon the rights. Now A promises to paint a picture for B. B afterwards forbids him to do so. He prevents him to do so. So waiver of the right on the part of B results in discharge of contract. He says, you need not paint any picture for me. I'm not going to take any action against you. Here the contract will come to an end. And now the third point is the third main point in which the contract gets discharged, that is impossibility of performance. Now section 56 provides impossibility can be of two types. One is initial impossibility or pre-contractual impossibility, and second is subsequent impossibility or post-contractual impossibility. And subsequent impossibility is also known as supervening impossibility. Now, initial impossibility, friends, it may be known to the parties or unknown to the parties. Person who has died, he cannot be made alive. Unknown to the parties, in case of bilateral mistake, where both the parties are under mutual mistake as to the existence of the subject matter, but they are not aware, then this impossibility is also initial. So in case of initial impossibility, the agreement is void. Subsequent or post-contractual impossibility, a contract to do an act after the contract is made becomes impossible by reason of some event which the promiser could not prevent. Unlawful, becomes void. So when we talk about, friends, when we talk about subsequent impossibility, subsequent, when the contract is made, it is very much valid. And subsequently, later on, in the future period, due to some reasons or factors, the valid contract is transformed into void. Then also, friends, the promiser is discharged from his liability. Excuse is given to the performer, to the promiser. Then the other party has no right to file a suit against the guilty party. So now the question arises, which are the cases which have been covered by the doctrine of subsequent impossibility? Which are the cases where this doctrine of subsequent impossibility applies? Meaning thereby that performance is excused. And 5 points are there, 5 to 6 points are there. I'll take up all the points and I will explain. The first one is destruction of the subject matter. When subject matter is destroyed after the formation of contract, but before performance, then this will transform the valid contract into void. Taylor versus Caldwell, this is a very important case law regarding this, where the hall was taken on rent basis for series of concerts. The hall was accidentally burnt down before the date of the first concert. So here, friends, the hall was burnt down before the concert. So here the contract had become void and C was not liable. Change of law. Any change in the law or change of government policy that will also transform the valid contract into void. The case law is there, Shipton, Anderson and Company versus Recipto. In this case law, A agreed to sell B a specific parcel of wheat in a warehouse. Before the delivery of was given, wheat was requisitioned it was acquired by the government under statutory power. Held both the parties were discharged from the performance of such contract. Third is non-existence or non-occurrence of contemplated state of things. If for performance of contract, certain contemplated state of things should exist, because that is the sole basis of performance of contract, and they do not exist, then also the contract is discharged. Here the flat was hired for 2 days to witness the coronation procession of the king in 1902 in the case law of Krell versus Henry. But somehow, what happened, the procession has to be abandoned, had to be cancelled. So it was held in the court of law. There was no obligation by the hirer. Hirer was under no obligation to pay the rent, as the existence of the procession was the sole basis of the contract, and its cancellation discharged the contract. Next is declaration of war. You all know, friends, alien friend can contact, alien enemy cannot. When war takes place between the two countries, alien friend get converted into the alien enemy, then the war has to be suspended. It can be revived after the war is over. Next is death or permanent incapacity of the promisor. Wherever the contract is of personal nature, teaching, learning music or giving performance of the song or dance. Here, when the promisor dies, then the contract comes to an end. Or, take the example of carpenter. Carpenter has to manufacture a dining set, but after the formation of contract, but before the dining set manufacture, what happens? He meets with an accident and he breaks his right arm in the accident. He is not capable of doing the work. Then also the contract will get discharged. The other party will not have the right to file a suit against the carpenter. So 5 points I've covered in my video lecture class, friends. These are the cases where doctrine of subsequent impossibility applies. Or we can say in other words, where excuse is given to the performer of the contract. Performance is excused. And now, friends, hurriedly I will take up exceptions. There are 5 to 6 cases where, this doctrine is not applicable. Or these are the cases where performance will not be excused. First is difficulty of performance. If performance is possible, but it has become difficult, as it happened in this case law, which is before you. So here, difficulty of performance will not provide any excuse to the performer. Self-induced impossibility. If, self-induced, a person has invited problems. And now, as the example is before you, if a person is held guilty of a crime, he has committed crime. Why he committed crime then if he entered into the agreement? No, he has committed crime and he fails to perform his part of obligation, then he will not be discharged from his obligation. So self-induced self-created impossibility will not provide any excuse to the promiser. Commercial impossibility. This commercial impossibility occurs when the performance of a promise becomes costlier, less profitable, or more dangerous. Performance is not excused in such cases. So here, friends, whatever was the agreed price, at that price, the promiser is bound to deliver the goods to the buyer. If prices have gone up in the market, he cannot say that I will not deliver the goods because now, if I sell the goods to you, then I will be suffering certain amount of loss. So friends, commercial impossibility also is not covered under the doctrine of subsequent impossibility. Impossibility due to the default of a third person or conduct of a third person. There is a default on the part of a third person. Then also, friends, that will not provide any excuse to the performer, because here the case law is before you. X wholesaler entered into a contract with Y for the sale of certain type of cloth to be manufactured by Z, manufacturer of cloth. Z did not manufacture the cloth. Held, X was not discharged from the contract and was liable to Y for damages. So here there was a default on the part of Z, but X was not discharged from the contract. Next is strikes, lockouts, and civil disturbance. If strikes take place due to any reason, lockouts, there is lockout of the factory, or there is any civil disturbance, then also no excuse is given to the promiser. Once such event is over, then the performance of the contract is possible. Failure of one of the objectives. If there is a failure of one of the objective has not totally failed, but partially it has failed. See, hall is taken for two purposes. One is the celebration of marriage, other is celebration of birthday ceremony. No, marriage somehow gets cancelled or gets postponed. Then it means the objective has not totally failed. It has failed partially. Then the party will not be discharged from its liability. And now, friends, I will take up effects of subsequent impossibility. There are 3 effects. One is contract becomes void. You all know, friends, that valid contract is transformed into void. Second is compensation for loss through non-performance of act. Any loss which is suffered by the party, the other party's duty is the party must compensate the other person for the loss. Third is principle of restitution applies. You all know, friends, this principle of restitution to restore the benefit to other person from whom the benefits have been derived. So this principle of restitution will apply. Now the next point is discharge of contract by lapse of time. Time lapses, which results in termination of contract. Under the Law of Limitation Act, the debt becomes time-barring debt after 3 years. 3 years period is over, then also the contract will come to an end because the debt has become time-barring debt. So lapse of time also results in discharge of the contract. Discharge by breach of contract is the second last point. Breach already I have defined in this video lecture class. So friends, in case of breach, there are certain remedies available to the aggrieved party, and these remedies in detail I will discuss under chapter number 10. Discharge by contract by operation of law. The law operates and it results in termination of contract. There are 4 ways in which the law operates and the contract comes to an end through operation of law. First one is death. The contract which is of personal nature. When the promiser dies, unfortunately, before the performance of the contract, then the contract will come to an end. But if the contract is not of personal nature, this will always bind the legal hire or representative of the promiser. Material alteration. Any alteration which changes the rights and obligations of the parties. This is known as material alteration. Material alteration also, material alteration Non-material alteration or authorized alteration does not affect the validity of the contract. Merger, change in the, say for instance, change in the check amount or date. Okay, so that will amount to material alteration and that will not be valid. Merger is coincidence of the superior and the inferior rights. Say, for example, the part time lecturer becomes full time lecturer, or tenant becomes the owner of the same house. Okay, then in that case, the contract of tenancy will come to an end, or in case of lecturer, the contract of part time lecturer will come to an end. The last point is insolvency. In case of insolvency, also, the insolvent person is discharged from his liabilities. That is, all assets, all liabilities, they are transferred in favor of a person who is known as official receiver or official assigned. So the insolvent person is discharged from liability on all the contracts entered up to the date of insolvency. So friends, I have explained all the points. Two questions were very, very important, which are the various modes of discharge of a contract and doctrine of subsequent impossibility of a contract, cases covered and cases not covered. So friends, this was all from my side for this chapter, chapter number 8. I hope you will like the content and do like my videos, do subscribe to my channel, do press on the bell icon so that you can get notifications of my future videos. So friends, stay healthy, be blissful. Okay, bye-bye. I will meet soon and goodbye.